All right. Is everyone here on the Cook Concrete versus WB Contractors? It's not quite 10:30 yet. Are you guys ready to get started, or are we waiting on anybody?
Your Honor, this is Mike Dingman for the defendants. Brittany Angelique and I are here for the defendants, and we're the only ones who will be attending the hearing, so we're ready to proceed.
Well, there's Mr. Ackles is here too. Is he not on this hearing?
Yes, sir.
Yeah, I'm having trouble getting my video to work. Good morning, Judge.
Okay, so I just want to make sure everyone's here. There's a Mr. Bagnall? Are we waiting on or Miss Bagnall? Are we waiting on that person?
I'll tell you that he is the newest plaintiff that joined. The case was transferred. His case was transferred from Collin County, I believe, and I don't know if he's joining the hearing or not.
Do we want to wait, or what do we want to do?
Defer to you, Your Honor.
He's not a part of this dispute of the motions to compel. He's not a part of that.
Okay. Well, I guess let's get started. And if he signs on, he doesn't have a dog in this fight, is what you're telling me.
He is a party to the case, but not to these motions to compel.
All right, let's go on the record on DC 24-19714, Cook Concrete versus WB Contractors of Texas. Counsel, make appearances.
Good morning, Your Honor. Michael Dingman, McGuire Woods for WB Contractors of Texas, LLC, as well as the other defendants in the case.
Good morning, Your Honor. Samuel Ackles and Joseph Ackles Sr. appearing on behalf of Cook Concrete LP, the plaintiffs in this case.
Brittany Angelique on behalf of the Willow Bridge defendants with Mike Dingman.
Let's proceed.
Right, Your Honor, we have filed a motion to compel against Cook Concrete that involves three issues. Their responses to a second set of interrogatories, which responses were provided on August 7th. Their production of documents that did not comply with the instructions on how to produce those documents. And then our efforts to take a deposition of Crystal Zimmerman, who's an employee, seems like the chief financial person for Cook Concrete. And that's an individual deposition, Your Honor, not a corporate deposition. So let me start with the second set of interrogatories. And there are three interrogatories, Your Honor, that are the subject of the motion. Two of them relate to interrogatories requesting that Cook set forth the damages it's seeking in this case and the basis for them. Those are interrogatories 20 and 22. And
Go
then
ahead and share screen those interrogatories.
I'm sorry, sir?
Go ahead and share screen the interrogatories.
Let me see. It's Exhibit B to our motion to compel.
I'll share those 1 second, please.
Everything okay? There we go.
Yes.
So the first interrogatory at issue, Your Honor, was interrogatory number 20, which asked Cook to describe the delays or the damage for delays. It's with respect to the delay events, it identified in response to interrogatory 19 and how they calculated those delay damages. Cook referred to an Exhibit A that sets forth those details. And Brittany, if you could scroll down to that Exhibit A. That's good. So the issues we've raised in our motion to compel, Your Honor, is So Cook identifies the cause of the delay. It tells us the dates during which the delays allegedly occurred. And then the last category is amount that they're seeking as damages with respect to each delay event. And so the challenge that we have and the issue in the motion to compel is on a number of these categories, they say, for example, what's highlighted, seeking damages, but still calculating the amount through discovery. And if you look at the period during which this delay occurred, it's almost, well, it's more than 2 years ago. And they've not told us what amount they're seeking for that delay event, same for the next one. You'll also see that in their amount, they have this statement again and again, seeking credit for time of delay. They've not told us what that means or what they're seeking with respect to that statement. If you scroll on down, you'll see the same issues on the rest of Exhibit A, where they say not seeking damages, seeking credit for the delay, but not telling us what that is. There's another category where they say they are calculating their damages. And so they've not really answered that interrogatory to tell us what the damage amount is that they're claiming and how they've calculated that. And as the court is aware, under Texas Rule 194.2B, they're required to disclose that information to us, and they have not done that in their disclosures, which we also attached to our motion to compel. So with respect to interrogatory number 20, Your Honor, the request is that Cook has to set forth specifically the amount of delay damages it's seeking and how it calculates those damages.
Response?
Yes, Your Honor, 2 points of response here. One, with regard to the issue of it not being in the disclosures, our outline of our damage packet states in it that we are incorporating it as part of our disclosures. The biggest issue, Judge, and if you look at what we've calculated, it's here, put out before the court of the specifics of all our delays, along with a response to interrogatory in our third set of responses, which I attached for the court, where we line itemed every single one of these damages. The reason we think this is sufficient for where we're at in the issue is that 2 things are happening in this case that's causing a problem. One issue is that some of these delays and costs are things, or actually the majority of them, deal with third-party vendors and third-party subcontractors, Your Honor. For example, the plumbing is a prime example that's relevant for this motion, where our party, our client, was terminated for convenience in this case so that the defendants could go back around and deal with these individuals directly. They are settling and offering settlements to those individuals, which impacts our damage model when it comes to interest on delays, what we owe them, how much we can claim. And they've done this multiple times without disclosing to us what they've settled, how much. A good example is Nelson Brothers, who is in this lawsuit. They've sued. We had to move to transfer venue here. There's been some sort of behind-the-scenes settlement with the defendants and Nelson Brothers. They haven't disclosed to us the amount that I'm aware of, but Nelson Brothers maintains that we, Cook, still owes them money, and that impacts our damages. It impacts what we can calculate on delays. It impacts our interest. This is the case with Barnsco, Martin Marietta, the other vendors. And then that's also subject to our motion to compel that's set later about some of these issues. But part of the issue with the calculation of damages, Judge, is that behind the scenes settlements are taking place. We think out of convenience. It was the reason that we were terminated in the first place, was so that they could do this. And it impacts our ability to calculate these damages to the correct extent. And we've addressed this, and that's where we're at. So I think that what we've provided is pretty detailed and sufficient about our actual damages, where we stand. And I've talked to my client about an estimate, but we do have this issue of what's settled behind the scenes that impacts our numbers.
All right, you're going to need to supplement with whatever you can in the next 7 days, or
okay.
So, all right, what else you got?
So we can clear on that. We would like for them to tell us specifically the damage amount and how they calculate it. That's never been done.
Yeah, you're required to do that. But I think he's kind of done that here, hasn't he? I mean, that seems to be kind of what he's doing.
No, sir. So let me explain. What they're showing is the second interrogatory on damages that we have an issue on, okay? Nowhere in there do they set out their delayed damage amount. That was interrogatory number 20. And counsel suggested there was some supplement where they laid out those damages. That's simply untrue. The only information they've ever provided on their delay damages is the Exhibit A that we walked the court through. And none of that has anything to do with potential settlements with others. These are delays that ended almost 2 years ago. And Cook is saying to this court, it's not able to tell the defendants what it's claiming or how it comes up with these numbers less than 2 months to trial. So we need them to tell us exactly what the amounts are and how they're calculating them so we know how to defend against them.
Well, I think in some of those they did and some they didn't, but to the extent you haven't done it, you have to supplement that within 7 days.
Yes, Your Honor.
All right, what else do we have?
Staying with the damages issues, Your Honor, interrogatory number 22 is also part of the motion to compel. And you will see that there are numbers that are set out in response to that interrogatory. But throughout their response, the plaintiffs say this is not their final. They want to receive additional discovery before they finalize their damages calculation. And when you walk through what they've stated
Okay,
here,
they need to fully supplement within 7 days. I mean, that's where we are. Then, so you guys are set for trial in 2 weeks?
2 months, January 6th, Your Honor.
Oh, they said 2 days. Okay.
We have we do have a motion on that before the court set December 8th, Your Honor. Whether or
Motion to
not
consolidate or continue?
both, Your Honor. I get we can put a pin in that, but there are multiple subcontractors that are being we think are necessary parties in this case that are still waiting to be consolidated, and then we have these discovery issues, Your Honor, and it's a complex litigation. I can get into the continuance argument now, but that's set December 8th if the court wants to entertain it. But that's one of the issues in the case.
And I will say this just to preview it, you may want to talk to him. I have a huge special setting on January 6th, the biggest case probably on my docket right now. So you may want to talk to that case. Jeff Tillotson and Mackenzie Wallace and a bunch of other people are involved in that case. And so you may want to talk to them. They were specially set before, and then it didn't end up going for not because of me, but the parties. And so I don't know if the case is going to go or not, but you probably want to talk to them about that trial setting, just FYI. So
thank you, Your Honor.
They would go ahead of you if they go. So I don't think that case will settle, but you never know. So, all right, what else do we have?
There's just one other interrogatory, and that's interrogatory 21, which asked Cook to state the basis for its allegation in its amended petition that there are safety issues with the structures at Katy Trail. In their response, they objected and stated that they needed additional discovery before they could answer this request.
This objection's overruled. You need to answer within 7 days.
Your Honor, I responded last week with a supplement to this interrogatory, and I think what I've responded is sufficient. However, there are some outstanding discoveries still that's subject to our motion to compel that's set today.
Yeah. And Judge, if I could address that, there are 2 things that I want to point out because I think it's important for the court to understand what's going on here. This has been the issue that Cook told this court is the most important issue in the case. And they demanded discovery on it. We've provided the discovery. And one of the things you'll hear from Ms. Angelique is Cook has been in possession of all of these test reports and documents it says it needed to answer this interrogatory based on its involvement in the project. In other words, those documents were emailed to Cook during the project. We produced them again in June of this year. And the plaintiff is still suggesting, even though it has almost a dozen allegations in its petition, that it cannot tell us what these issues are. As to the supplement, we received it Friday afternoon. It's all of 2 paragraphs, and it says the following, Your Honor. Subject to said objections, with the information that is available to plaintiff, still suggesting they need information for allegations they made a year ago, plaintiff's concerns of the safety of the structures arose due to disturbed and damaged piers. Plaintiff became aware of the engineer's letter requiring proper density pursuant to the geotechnical report at each of the disturbed and damaged piers. Plaintiff requested defendants to provide proper documentation to support backup at the engineer's report. They do not say what the damaged piers are or what disturbed the damaged piers.
Well, hold on. I have to object. He's not reading the whole answer.
Okay, well, let me
He's only
finish
selected
then.
certain
Let me
things.
just go ahead and finish that.
Guys. I'm overruling the objection. You have to answer it within 7 days. That's all.
Okay, Your Honor. I guess I just need to know if what I've supplemented is enough.
Well, Judge, let me just go and address that. So that, you know, counsel doesn't think I'm leaving anything out. Here's what I didn't read. Defendants failed to provide proper documentation and information about these concerns. Doesn't tell us anything about what the concerns are, what the peers are.
If that is the case, that is not sufficient, and you need to answer it fully. So I don't know if there's more to it, but
Well,
There's more. There's more in the
point
answer,
out,
Judge.
Your
But
Honor,
we'll.
the
we can pull
objection,
these
the
up.
objection,
So-
the object, guys, I don't know what else to do. The objection is overruled. You need to answer within 7 days, and that is
But-
not sufficient, what you provided.
The only other thing I want to point out, Judge, is they go on to say,
Mr. Dingman, I've already ruled in your favor. I don't know what you're doing here.
well, my concern, Your Honor, is they're going to say we've already supplemented, we're not going to get any additional answer.
That would be extremely risky for them because I've already ruled that answer is insufficient. I've already overruled the objections. They need to fully answer this question. And so there's nothing else. You're asking me to rule on something they haven't even done yet. So I've told them it's insufficient. I've told them that there's nothing else I can do for you, Mr. Dingman, at this point.
All right, sir, I just want to note for the court, we've been trying to get this answer for a year.
Well, I've had to. You asked me about it 2 minutes ago, and I made you a ruling. So I don't know what else to do. You need to answer it fully, Mr. Ackles, and the objection's overruled.
Yes, Your Honor.
The next issue on our motion to compel, Your Honor, has to do with production of documents. And it's a fairly straightforward issue. Plaintiffs produced in the neighborhood of 60,000 documents. And in particular, there are a number of emails, and our instructions, similar to their instructions to us, required those emails to be produced in native format. And they instead converted them from native and produced them in PDFs. And so a lot of those emails, one, they're not searchable. A number of those emails refer to attachments that are not part of these PDFs. So we don't know where those attachments are in the production. And so what we would ask is that they simply produce the emails in native format, which we assume they received them in that format, so that we can search them and make sure that we know where the attachments are referenced in those emails.
I think that's required by the rules, is to provide it in native format. So, Mr. Ackles, you need to provide that within 7 days in native format. All right, what else do we have?
Your Honor, I just, the only caveat is I don't know that our IT people, which will be outsourced, can do it in 7 days. That's the only issue I have. I don't know the answer to that. We can try, but it would help if we could get 2 weeks. Because I don't know, because every time I deal with them, it's problematic.
Why don't you guys do this? Why don't you talk to your IT guys, Mr. Ackles? If it's a problem getting it done in a week, then sign back onto the Zoom at 2 o'clock with all parties. and with the IT person so I can figure out what the appropriate amount of time is.
Okay, we'll do that.
All
Thank
right,
you.
what else do we have?
Your Honor, the last item in our motion to compel is the deposition of Crystal Zimmerman as a fact witness who's an employee of Cook Concrete. On Friday, we received proposed deposition dates for her, including one for December 3rd, and that's available for us. So we would just ask the court order her to appear for her deposition on December 3rd.
Order to appear in Mr. Ackles' office on December 3rd at 10 o'clock.
Thank you, sir. That's all that we have for our motion to compel.
All right, guys, you have a great rest of your day.
Judge, I have.
Sorry. One more, Mike.
So
We forgot the
Oh,
verifications.
I'm sorry, Judge, there is one more. We have received several interrogatory responses and supplements. None of them have been verified by Cook Concrete. So we have 5 or 6 interrogatory responses with no one signing them on behalf of Cook.
Judge, two things. May I respond to this verification argument? Because there's an exception in the rule to verify interrogatories based on contentions. And I think almost all the interrogatories, if not all of them, are contentions under 197 4D verification exceptions. A party need not cite answers to interrogatories about persons with knowledge of relevant facts, trial witnesses, and legal contentions. And every single, almost every single, I think there's only 1 or 2 outside, but every single says your contention, your contention, your contention. And I think there's an exception in the rule on verification of interrogatories on contentions.
Your Honor, what we've asked is tell us the fact basis for the allegations in your case. Tell us the fact basis for your damages.
That's not what it says, Judge.
And so
It says your contention.
It seems like they don't want anybody from Cook to actually sign.
Have
these
you
responses.
provided any verification at this point, Mr. Ackles?
I don't believe so, Judge.
So you need to provide a verification that complies with Rule 197.2 and the verification exception. So some of these, I'm sure they're not all, you even said they're not all contention interrogatories. You need to provide a verification within 7 days that complies with Rule 197.2.
Judge, may I ask one question on that? Would one verification for any that notifies every one of our responses, because we've supplemented 4 times, do, or do I need to have 4 verifications?
I mean, I've never seen people verify it that way. Usually the verifications are just done at the beginning, but you just need to comply with the rules.
Okay. I think we'll do one that identifies them all.
It's a good idea. It'll be easier.
Okay.
All right, guys.
Judge, I have a motion as well set today on our motion to compel documents.
Okay.
I attached as exhibit.
I don't see that. I only see one motion being set today. There was 2 motions set?
I called the clerk last week, Judge, and told them that we have a compel as well, and she said it on the same day, so I issued the notice.
It's not, you may have done that, it's just not on here. If you can do it in, I have probably 5 minutes. If you can do it in 5 minutes, I can do it. But let me see, it's a second motion to compel. Is that right?
Yes, Your Honor, and what we're asking for is attached to the exhibit in the motion. I will tell the court I had about 34 requests that I spoke to Ms. Angelich about. We did conference. I withdrew my requests on the ones that she provided Bates label documentation on that were responsive. So these remaining requests are key to the case, and I've not received any Bates label numbers that verifies their position on these, especially requests 1 and 2.
All right, well, let me try to roll on 1 and 2 then.
Your Honor, if I may, our response, this motion was noticed last Wednesday, which would have been the day that the response was due. So our notice or our response was filed on Thursday, which was timely given when when this motion was noticed, and I can pull up our responses for the court's convenience, but essentially the argument is that we have not produced documents related to re-excavations or backfills near the Cook concrete piers, and that's just not true. I can point to a number of ECS reports that are the testing facility people that are out on the property at the time. For example, if we want to look at the January 18th, 2024 ECS report.
So let me just say this, Miss Angela.
Yes.
How do you say your name? I don't want to mispronounce it.
Angelich.
Angelich, Miss Angelich. I don't here. Let me do this real quick. So this is what you wanted me to try to rule on, right? Okay. So is this the most recent response?
Yes,
Yeah.
there's an original response, Judge, that where they take the position that we're not entitled to these documents at all. I had a call with Miss Angelich about it. She said she would review for supplement in response. Still asked me why these documents were relevant. We got an amended response where they're not waiving any objection, saying they're unaware of excavations, unaware of backfills, which I include in my documents, some of the documents they produced, which reference excavations and backfills. And then they said that they've already previously produced documents that they said we weren't ever entitled to. I will tell you, Judge, there have been some production on this matters. However, there are third-party production, for example, on the plumbing, on certain re-excavations, where we have been told that they're not going to produce these third-party communications. And there have to be relevant communications out there that haven't been produced, Judge, based on some of the documents that have been produced. And that's why I attached that to my supplemental evidence in the binder I sent over to the court. So specifically, they have areas in their production that bring up how Power Plumbing did.
Guys, I don't think this was set today. I'm trying to accommodate you, so I have to do this quickly. So number one, I'm going to sustain the objection. Number two, I'm going to overrule the objection, and I'm going to order you, Ms. Angelich, to identify by Bates number any documents responsive to number two. All right, guys. You guys have a great rest of your day. Get me an order on this. The order should say that this was heard on November 17, 2025 over Zoom. All parties were present. It was on the record. Give me a copy of that order by tomorrow.
Your Honor, if I sorry to do this, but the issue with number two is that it's related to backfill procedures. And we responded that we are not in possession of documents related to backfill procedures. But to the extent there were documents related to backfill, those have been produced. So that was the reason for our objections. And if we want to narrow it to just backfill, we can identify those documents. But I just wanted to be clear that our amended response said we don't have possession of documents related to backfill procedures.
You identify documents that you had documents. I'm overruled an objection. You're required to answer it and identify the documents you're referring to by Bates number.
Understood, Your Honor.
All right. Anything else, guys? Mr. Bagnall, were you on this case?
Yes, Judge, I represent Cook Concrete on this one. I was just.
What?
No, you don't.
No, you don't.
I'm sorry. I'm sorry. Nelson Brothers.
Okay. Did you want to say anything?
No.
All right. Okay, guys. You have a great rest of the day. Get me that order by tomorrow, okay?
All right,
Have a
thank
good
you.
day.
All right. You have a great day. Ms. Anderson, what are you here for?
Sorry, I'm trying to get unmuted. I received I'm trying to get my camera on, excuse me.
Okay.
Okay, there it is. I received an order of notice of hearing from Ames Meadow Association, Henry Otto, Austin and Fletcher. It's
Yeah.
Homeowners
Got it.
Association motion to reinstate? Yes,
Oh, yeah, that's for 11 o'clock. Okay.
yes,
We will see you at 11 o'clock.
okay.
All right. Are you here for the motion to reinstate?
Yes, Your Honor, that is correct.
Okay. Tony, are you ready?
Yes, Your Honor, I'm ready.
And I'm sorry, I'm talking to my court reporter.
Sorry.
Yes, Judge.
Let's go on the record on DC 257659, Ames Meadow Homeowners Association versus Anderson. Counsel, make your appearances, and Ms. Anderson.
Yes, Your Honor, Claudia Zisman Monzon on behalf of Ames Meadow Homeowners Association, Your Honor.
Ms. Anderson, if you could state your name. You need to unmute.
Anderson.
All right. So the plaintiffs have filed a motion to reinstate. Ms. Anderson, are you opposed to that?
No, if I'm making sure I understand correctly, reinstate is like basically, I don't know. I know what the word means, but I want to
You
make
want
sure I
to put it-
understand.
So this is the deal. So let me see if I can read it. Yeah, all right. So they filed the default judgment. As I understand it, did you guys work out an agreement with Ms. Anderson?
Your Honor, yes, if I could provide some information. So after the case was dismissed, our office has worked with Ms. Anderson to come to a payment plan agreement, which we have. Ms. Anderson has also signed an agreed order that we have. ready to be put on file should the court reinstate the matter. So essentially, we've worked out a payment plan, a monthly payment plan, an agreed order, a proposed agreed order has been signed, and
She will
so
not be foreclosed on, correct?
correct. As long as Ms. Anderson follows the terms of the payment plan agreements.
And if she doesn't, then what happens?
Then pursuant to the agreed order, then the association could proceed with foreclosure. But hopefully that won't have to happen, but that's kind of standard as to what our agreed orders say, which, I mean, I'm happy to file with the court for review.
Ms. Anderson, does that comport with was that sound like what they agreed to with you?
Yes, sir. Yes, Your Honor.
So are you okay with them reinstating this so they can enter in this agreed order?
Yes, Your Honor.
Okay. All right, so let me take a look at what I've got here. It looks like there's an order to reinstate.
Correct, Your Honor. I don't believe we've filed the agreed order yet, as we were waiting to see whether the matter would be reinstated, and then if so, then we would file the agreed order.
And she's already signed off on the agreed order, is that correct?
Correct, Your Honor.
Okay. Ms. Anderson, I'm so glad this all worked out for you. This is why we have this program in place, to try to make sure that we can save people's houses and give people a chance to save, or give people a chance to save their houses. And so I'm glad this worked out and you were able to save your house.
I appreciate it.
It's a lot of judges unfortunately don't do this, and people get foreclosed on when they don't need to be. So all right. Rhonda, put this for now on the January foreclosure docket.
Okay.
And then if they get this agreed order in, it will probably close the case.
Okay.
All right. And so Ms. Anderson, I think we've talked about this before, I believe, but if I haven't, then just ask me. So this will be set on the last Friday of January for a hearing at 1:30. I would strongly recommend that you call Rhonda, who's Rhonda Pinson. She's my court coordinator, the day before the hearing, just to ask her, hey, do I still need to show up? Because as of right now, you need to show up for that hearing. And so I would put that on your calendar of last Friday at 1:30 in my court. You'll get a notice in the mail. The only person who's allowed to excuse you from that hearing is Rhonda. So even if a nice lady here, Ms. Zisman Monson, says you don't have to show up, I would strongly recommend you call Rhonda just to make sure, because I have seen, not her, but other attorneys who have still gone through with the foreclosure because the other person, because the person didn't show up. So does that make sense to you, Miss Anderson?
Yes, absolutely. So I need to call Rhonda before that, maybe
The
like
day
the week
the
of,
day before the
the day
morning.
before.
The day before
January
the morning.
30th, 2026 at 1:30 is when the trial date will be set for foreclosure.
Or the hearing
What
date.
was the date again?
January 30th, 2026.
So I need
Is
to
the
call you on the 29th.
Yeah, the
Okay.
29th or the morning of the 30th, but but you might want to do it the day before just in case, and just to verify there's nothing's happened, because I'd hate to see you lose your house because you didn't make a phone call. So and if she tells you to show up, then you absolutely 100% need to show up.
Okay.
We just want to make sure you keep your house, okay?
Okay.
Ms. Anderson, I wish you the best of luck. I'm really glad this all worked out for you, okay?
Okay. Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you.
May I
All
be
right.
excused, Your Honor?
You both may be excused. You guys have a great rest of your day, okay?
Thank you, you as well, Your Honor.
Thank you as well.
Mr. Harder, let me look this up real quick.
Good morning, Judge.
Good morning. Are you here on the Icon construction case?
Yes, I am.
Okay. Lou. Okay, so we're going to be tight, really tight for time. I hope this is a short hearing. So let me do.
It should be short, Judge. The parties are agreed on this. We had a trial. We were before you was a Zoom trial, and then before we concluded, you had us go visit, and we visited. We came up with a resolution. We've got a settlement agreement that's been signed, sealed, and delivered. And then later on, you had entered the final judgment, which was a surprise to both parties. And so I had conferred with Mr. Siebert, and Mr. Siebert is in agreement with the motion. And I think he signed off on both the motion and the proposed order. So
Okay.
we're just trying to kind of clean it up is all.
Yeah, let's just clean it up. But 11:15 is when the hearing's set for. So I don't want
Right.
to.
Yeah, so I'm hanging out. So whenever you're ready to call it.
All right, I'll be back in a second.
Okay.
Oh, and if you can get Mr. Siebert to sign on early, that would be great.
Let me see if I can do that.
Thank you. Hey, you guys ready? On the other
I'm
side
sorry.
is-
Yeah.
So,
Yeah, I don't know. I emailed Mr. Siebert. I hadn't heard back from him yet. He maybe is not intending to show up since he's agreeing with it. I think when you look at the order that we uploaded with the motion, you'll see that he did sign off on it as agreed.
yeah, I'm just not sure exactly what you're, I guess, trying to do here. You want to vacate the judgment and then what?
Well, and then we'll just not suit with prejudice. We'll send in a joint non-suit with prejudice. We've got, like I said, we've got a settlement agreement that everybody signed off on. And so when the notice of the judgment came down, it was a surprise to both of us. So I don't know what was going on in the court with it coming to your attention and you entering it. But in any event, we had announced a settlement in court, and we announced the terms of the settlement, and then we did reduce it to writing.
Okay. All right, I'll vacate it. Rhonda, you there? Rhonda? Rhonda, you there?
Must be on the phone.
Give me a second. Let's see. Rhonda, are you there? I'll just send her an email, I guess. Okay. All right, I've signed the order to vacate. How quickly can you get in the dismissal?
Well, I'll try to get it into you this week, Judge. I'm going to go ahead and send it off to Mr. Siebert to sign off on, and then as soon as I have it back from him, because I'll do a joint notice. I think he had a counterclaim, and then I'll send it in with an order.
All right, sounds good. You have a great rest of your day.
Well, thank you, Judge. Nice seeing you. We'll see you next time.
All right, thanks. Bye.
I bet she probably ran to the ladies' room or something.
Yeah, it's okay.
Hey, Judge, I'm back.
Okay, this DC 238907. Sending you an email about it. We just had a hearing on it.
Uh-huh.
I'm reinstating the case. We need to put it on a DWAP docket.
Okay. Okay, got it.
I'm sending you an email. Put it on a 14-day DWAP docket.
14 days. Okay. 14-day DWAP. Got it.
All right, guys, I got to go. I will see you at, what is our hearing?
I think 1:30, but let me make sure.
I have at lunch. It may take a while. I'm a little worried.
Okay, you want me to tell him anything or just, a motion to compel is at 1:30. Hi, I'm so sorry. Hi, this is Rhonda. How can I help you?
Do you remember there was this case that judge signed an order of non-suit and then he signed an order to withdraw the non-suit?
Uh-huh.
Well, anyway, this lady's calling because she wanted to check on the motion for continuance. The trial date looked like it was taken off, but it was never put back on. Never put back on.
Okay.
So she wanted to know, you want me to go ahead and resend you that order of continuance?
Yeah, was there a date put in there? Or
Yeah, it was set for December the 2nd.
December 2nd? Okay.
It was non-suited at first, but then they withdrew it. And so now I guess the trial date would have to go back on there, and then I'll forward you back the order of continuance.
What's the case number? Because, yeah,
It's 24-14325.
Cause usually if whatever the previous trial date was, if it opens back up, I put it back on the same one.
Because she wanted that continuance to see if judge would sign it since she already withdrew that non-suit or whatever to see anyway.
Okay, so they wanna continue us on the December
December.
2nd date anyway?
They want to continue that December 2nd.
Judge, how far you want me to do it 30 days or January, February? I think he's gone. Okay, I'll go ahead and put it on the February docket.
Yeah. Okay, so you want me to just tell her it's been?
Yeah, since I gotta reset it anyway, so, it'll be February, 23rd, February 23rd,
February
26th at 9 AM, yeah.
9 o'clock. Okay, all right, I'll tell her.
Okay, thanks, all right, bye.
Bye-bye.
So I run, I guess we come back at 1:30.
Yes, I think it's 1:30. I think it's the next one, yeah. Unless they change, but I think it's a couple of them. Let me check real quick, hold on. Yes, baby, hey, how you doing? From Chalk State? From home? From downstairs. I don't know how good it is to taste it. So it looks like we only got one at 1:30, but if they cancel anything, then it's gonna go to 2. But as of right now, it's 1:30.
Okay, thank you. I'll see you then.
All right, I'll see y'all later. Bye.
All right, good afternoon. Apologize about running a little bit late. Can you guys hear me okay? Can y'all hear me okay?
I can hear you now.
Yes, Judge, we can hear.
All right, are we here on the Dayu versus Flores case?
Yes, Your Honor.
Okay. And is the other side here? I only see one side here.
I'm not sure.
Okay. Well, Tony, let's go on the record on DC 254830, Dayu versus Flores. Counsel, make your appearances.
Central Walker on behalf of the defendant.
All right, you may proceed.
Yes, Your Honor. This motion was filed by the plaintiff to compel us to change our discovery responses, but we're asking that the court deny this motion as we complied within the Texas Rules of Civil Procedure with regard to our objections as well as to the actual information that we provided. No depositions were requested by the plaintiff in this case to get any sort of additional information that they didn't get from discovery responses.
So,
They are,
Mr. Walker, they're not here. So what
oh,
we're
sorry,
going to
my
do is
apologies.
just no, that's okay. I apologize again for running late. So I'm going to go ahead and deny their motion to compel. If you could put together an order for me that says that and write this down because you want to do it exactly like this. That this hearing was heard on November 17th, that the motion is denied, that it was held over Zoom, that it was on the record, and that the movement did not appear. And just give me a copy of that order by tomorrow, okay?
Can do. Thank you, Your Honor.
Thank you, Mr. Walker, and you have a great rest of your day, okay?
You too.
Thank you.
Bye-bye.
Tony, Rhonda, I just got back from this lunch, but the service was super slow and I didn't get to eat, so I'm gonna go eat right now. So I'll be back in a second. Okay, I'll be back at 2.
Okay.
All right, thanks, guys. Bye-bye. Good afternoon.
Good afternoon, Your Honor.
I believe
Mm.
let's see. Were you supposed to be here for the 1:30 hearing?
No, for the 2 o'clock, Your Honor.
Okay, you're here on the Huang versus Graulet Salas case, Josephat?
No, here for Dayu versus Flores.
That was set for 1:30.
Oh, I thought it was set for 2 o'clock.
I don't know. It's on the docket here. The other side showed up.
Oh, I'm so sorry, Your Honor.
Let me look.
I'll need
There's a
to.
notice here. Let me see. Yeah, the notice that your office sent out said was 1:30. So that's when the other side showed up.
Yeah, I'm so sorry, Your Honor. I need to go back and fix that, Your Honor. I'm so sorry.
It's okay. You have a great rest of your day.
All right, thank you, Your Honor.
Thank you.
Okay, bye-bye.
Okay. Our next hearing is Huang versus Graulet Salas Josephat case.
Yes, Susan Allen here for Castle Law, Your Honor.
Okay, is the other side here?
Yes.
Yes, Your Honor. Sam Polak here for William Fryer.
Okay. All right, and it sounds like there was a default judgment taken. You want to take you want me to vacate that? Is that right?
That's correct, Your Honor. Apparently he did not own the car at the time of the collision.
Okay. Let me look. I don't see an order.
I have a copy of an order. I'm hopeful that they signed it. If they did not, I'll get it defiled today, or that they filed it.
Let me see real quick.
I'm
No,
showing it.
it is filed. Yeah, it was just
Okay.
not supposed to be. I will go ahead and get that. You don't need it. Let me see. All right. And this is not going to affect the trial setting, will it?
No, they're just getting rid of a party that they shouldn't have sued to begin with.
All right, let's see. And then you guys gonna be filing a non-suit on this, or kind of how are you gonna get rid of the party?
Yes, it will be necessary to file a non-suit.
All right. Okay, I have signed the order, and you guys have a great rest of your day.
Okay, good to see you, Judge Hoffman.
Good to see
Thank you, Your
you.
Honor.
Good
Good to
you
see you,
guys.
Susan.
Hey, Sam, it's been a while.
It has been a while. Good to see
Hope
you.
that ankle's better. Thank you, Your Honor. May we be excused?
You may.
Okay.
You guys there?
Yep, that was sweet and easy.
Yeah. Of course, they're all like that. So our next one is at 2:45. Wait a minute. That was that one was set for 2:30. So our next one's at 2:45. Yeah.
Oh, so that last one was 2:30. Okay, the motion to reinstate? Or was
That was the Meadows versus Care Solutions.
Okay.
And then we heard that one in the motion to reinstate. And the Zwicky case is at 2:45. Just be aware the 4 o'clock. Can you grab Gary real quick?
Okay. Was signed. Trying to get the notes together. But the motion to reinstate, we didn't do that one, right? They didn't show.
No, the motion to reinstate on,
The motion to vacate.
no, I'm sorry.
Yeah, I thought that was the one that,
No, you're right. That's the motion. They're both by the Castle Law Firm. You're right. So the Huang case, our next hearing is at 2:30. Huang was the one I just did. So the motion to reinstate is at 2:30. Yeah. So they're just both Castle Law. So
okay.
Okay, all right.
Okay.
What was, okay, I just go get Gary. Hi, this is Rhonda with the 680 Square.
Yes, sir.
hey, Gary.
Yes, sir.
So at 4 o'clock today, we have a pro se litigant who's been pretty difficult. He's supposed to be on Zoom, but I just kind of wanted to give you a heads up.
Open the door.
Okay, he's supposed to be on Zoom, but I need to let you know if he comes in person.
Yeah, exactly.
Okay.
That attorney out there, he's still trying to get in. Did you see him? He just went up to the front.
Trying to get in, I just let him out.
Oh, you just let him out? Oh, well, there's somebody at the
Well, he
front.
already went over there, he already did the computer,
Well, somebody else on their way down. So I'm not quite sure what's going on. Okay.
you said at 4 o'clock, Judge?
Yeah, so I'm just telling you at 4 o'clock, there's a hearing with a pro se that's kind of difficult, and he may show up to the court. That's all I was telling you. So
What's his name, Judge?
Let me see. He represents Tamukan Trust. I don't remember his name. Let me see. Patrick Philpott.
Okay.
I mean,
All right, got it.
I don't think it probably almost surely nothing's going to happen, but I just want to give you a heads up.
No, I appreciate it. Thank you.
All right. So we'll see you at 2:30.